So what we'll do as just sort of an order of things, after I read the script, we'll have Mr. Wallace and Mr. Thompson for the private lawyers, and so that they can go about their business for the rest of the day.
Yes, Your Honor.
And then we'll go to the women, and we'll go to the men.
Yes, sir.
Okay. So good morning, everyone. This is your first appearance hearing before the Magistrate Court of Clayton County. My name is Brad Gardner, and I'm a judge of the court. I am not here to conduct a trial of your case or to take a plea in your case. I am here to inform you of the charges that have been filed against you, to advise you of certain rights, to set bail on those offenses that I'm authorized to set bail, to schedule a preliminary hearing, and to determine whether you require the assistance of an attorney. You have the right to remain silent and say nothing. But should you give up this right, anything you say during this proceeding may be used against you if your case goes to trial. So please don't discuss the facts of your case. During this and all other proceedings, you have the following rights: the right to the presumption of innocence, the right to indictment by a grand jury for most felony or by accusation or misdemeanors, the right to a speedy and public trial by jury, the right to see, hear, and question witnesses who are called to testify against you, the right to compel the attendance of witnesses to testify on your behalf, the right to testify on your own behalf or offer evidence in your own defense, the right to have an attorney represent you. If you cannot afford an attorney, one can be appointed to represent you if you qualify. Some of you will be allowed to post unrestricted bonds for your release from jail. And those bonds may be by cash, commercial, or property. If you post a cash bond, someone will deliver the full amount of the bond and fees in cash to the sheriff's office. The sheriff's office will hold the cash and return it at the end of the case. If you use a commercial bonding company, someone will have to pay a fee to the company for their service. The fee will not be returned. I don't know what fee will be charged, but it is usually based on a percentage of the bond. Finally, if you use property to post the bond, the property will need to have a net equity of at least 3 times the amount of the total bond. Some of you will have special conditions on your bond that prohibit you from contacting certain people or going to certain places. This special condition will be provided to you on a separate form. You will also be prohibited from contacting the victim while you are in jail. If you violate the court's order, your bond will be revoked, and you could remain in jail until your trial. You could also receive additional felony charges. It is important to note that if someone is listed as a victim in your case, that person will not be allowed to post your bond. Some of you are charged with offenses for which this court is not authorized by law to set bail. In this event, a bond hearing will be scheduled before a judge of the Superior Court of Clayton County, and you will be informed of that date. If you are currently on active probation, this court is not authorized to set bond at this time. Where the bond is appropriate in your case will be reconsidered after your probation officer has had an opportunity to consider this new arrest. The purpose of a preliminary hearing is to determine whether there is sufficient evidence to support the allegations against you. The standard at this stage is very low. A judge determining whether a charge goes forward at this stage only has to determine that it is possible that the crime occurred. Everyone has the ability to waive their right to a preliminary hearing. However, you should speak to a lawyer first if you are unsure about whether it is appropriate to waive your preliminary hearing. If you post bond, your preliminary hearing is automatically waived. You will receive notice at the address you give of your next court. Finally, I need everyone to raise your right hand. Do you swear or affirm that any statement you make during this proceeding will be the truth, the whole truth, so help you God? Okay. So we have with the attorneys that we have present, I believe Mr. Wallace and Mr. Thompson, Thomas Thompson. Is that correct?
Yes, sir.
Yes.
Okay, so we will address their cases first. So let's deal with Mr. Wallace first. Are you Mr. Wallace?
Yes, sir.
Okay.
I cannot see him in the frame of my.
Okay. What are you able to see?
He needs to move to the right. I can just see the side of his head. Okay, that's it. There we go. Okay.
Mr.
I got it.
Mr. Wallace, I'm going to address your attorney because you are represented by counsel. And so you are charged with possession of firearm by a convicted felon, and improper turn signal, and obstructing an officer. I will hear from your attorney as it relates to bond on this.
Yes, Your Honor. As to the charges, the obstruction, I understand, is a misdemeanor obstruction, and that is the relation to a traffic stop that was made on the 18th. My client was driving the vehicle. He was he exited the vehicle for the police officer. And during that moment, the passenger in the car jumped over to the driver's seat and drove off. The officer got in his vehicle and drove off after him, leaving my client on the side of I-285. I'm not sure where the obstruction comes from. There was a pistol in the vehicle, and it was handed over to the police officer before all that occurred. So he also had the identification of the passenger and my client and some other property of my client, but that is basically it. I have known Antoine and his family for a long time. Not so much Antoine, but I've known his family. He is, been a resident of the Atlanta area all of his life. His family is very supportive, and he will be living most likely with his grandmother when he is released on bond. He lives in Rockdale County.
Okay, looking at the warrants that were issued, I'm inclined to set a bond of $1,000 on the obstructing of an officer, $500 for the improper turn or signal charge, and $5,000 on the possession of firearm by a convicted felon.
All right.
And because the possession of firearm by a convicted felon is a felony offense, he would have a bond hearing date. A preliminary hearing date of April 7th at 8:30 in the morning. And that'll be by Zoom call, but that will most likely be.
He will be making bond, Your Honor.
Yeah, it'll likely be waived upon his bonding out. Do you have anything else for me?
No, Your Honor, I do not.
Okay.
And I will let Mr. Wallace know that I'll contact his family.
Yes, and Mr. Wallace, you should be in contact with your lawyer. Your lawyer will be able to inform you of everything that's going on, but you're now free to go back.
Okay.
And sir, you are free to go about your day.
Thank you very much, Your Honor. I appreciate it.
Okay, have a good day. So let's deal with Mr. Thomas Thompson next. Are you Mr. Thompson?
Yes, I am.
Okay, Mr. Thompson, I'm going to be addressing your lawyer. So you should just stand by and be aware that anything that you say is not privileged. So don't, discuss anything that you should not. It looks like, and are you, wait a minute, sorry. I may have pulled the wrong Mr. Thompson. Will you tell me your true and correct legal name?
Thomas L. Thompson, Jr.
Okay. I have another Thompson here. I'm sorry, I have a LaRon Thompson, and I think I pulled the wrong paperwork. Okay. So, Mr. Maloof, Mr. Thompson is charged with robbery. can I hear your statement as your client and
Yes,
what you should get done?
certainly, Judge. I have one brief question for the court. The date of incident, is that indicated on the warrant? I knew what the charge was, but I did not know the date of the actual incident.
Yes, it says on January 23rd of this year at South Lake Mall, your client is accused of committing theft by taking the property of, it says $500 in cash from Tiffany D. Evans by sudden snatching. And it says that your client took the cash from the victim's hand.
Okay. And Judge, I'll address what I believe to be relevant very quickly here. First, my client had sold a Honda Accord to an individual by the name of Tyree Bailey. That was not registered with the state. That's who we believe actually committed this offense.
Okay.
I think given that time frame that we're going to be able to establish an alibi on this case. My client is a business owner here in DeKalb County. He owns a car wash. He has no history of violence. He has some a couple of prior drug offenses. He has no history of fleeing any jurisdiction. He has resided in Georgia for approximately 10 years. We believe this is a case of mistaken identity. It is certainly out of his character. He's 45 years of age and has never been charged with anything violent whatsoever. His store that he works at, if this happened during business hours, should have cameras putting him there, and that's here in DeKalb County. Judge, at this time, we would ask the court set a bond of $10,000 cash, property, or surety. And we will look into this case further now that we know the date of incident. And Tyree Bailey goes by the name, the street name of T. So if they ran a license plate and then looked at my client's name, and it had not been registered to the actual owner of the vehicle, and that's how we're here, that's what we think happened. I think that this is something that we may be able to exonerate him on. That being said, Judge, we're not here to try the case. The charge is robbery. No one was hurt. It was $500. He has no history of anything like this. We'd ask for a bond of $10,000 cash, surety, or property. That's what we'd ask, Judge, and appreciate the court's consideration.
Okay. Mr. Maloof, based upon your representation, I'm willing to do that. So I'll set a bond of $10,000, and it can be made by cash, property, or surety.
Thank you so much, Your Honor.
You're welcome. So, Mr. Thompson, you're free to go back, and Mr. Maloof, you can enjoy the rest of your day.
Much, Your Honor. Pleasure speaking with you this morning, and you enjoyed the rest of your day and your weekend.
Well, I got a lot more work to do, so I'm gonna do the best I can.
Sounds good. Thank you, Judge.
Okay.
Bye.
You too. All right, let's deal with the ladies.
Okay, Judge. First one we're gonna have is Miss Ashford.
Miss Ashford.
Yes, sir.
You've been charged with having a license not on person, violation of Georgia Controlled Substance Act, which is a felony, use or possession of drug-related objects, and giving a false name, address, or date of birth. I'm going to set your total bond at $10,000. Do you believe you can post that bond, ma'am?
Yes, sir.
You're going to have a preliminary hearing date that's going to be set for April 7th. That date will be waived upon your bonding out. Do you plan on hiring your own lawyer representing yourself, or do you want me to see if you qualify for the appointment of a lawyer?
When I leave here, I'll be trying to get my own lawyer, but I would like to still put in for court appointed lawyer.
Okay. So based upon your representation on the form, ma'am, you do qualify. So I'm going to appoint a lawyer to represent you. And if you decide to hire your own lawyer, you just need to notify the public defender's office that you've hired your own lawyer, okay?
Yes, sir.
Do you have any questions for me?
No, sir.
Okay, you're free to go back.
Thank you.
Next is Ms. Cannon. Hey, Judge.
Good morning. Did I hear the name as Kent?
Canyon.
Give me 1 second, ma'am. I'm sorry. I'm sorry, man. It's not on your end. It's something that I am trying to figure out.
Yes, sir.
Could you spell your last name for me?
It's Canion.
Okay. Okay. Ma'am, I don't have a bond order on my side. Do you know what you were charged with?
Your Honor, I was charged with simple battery and I shouldn't have a chance. Like, I don't know.
Okay. What I'm gonna do, ma'am, is I have it. It was in the wrong stack.
Yes, sir.
Your first name is Tiawana.
Yes, Your Honor.
Okay. All right. So you're gonna have a bond set at $2,000 for the simple battery charge,
Okay.
and $1,500 for the disorderly conduct.
Yes, sir.
You believe you can post that total bond of $3,500?
Yes, sir.
Okay. You're going to have a preliminary hearing date set for April 6th at 8:30 in the morning, but that date is going to get waived upon your bonding out.
Okay.
Do you plan on hiring a lawyer representing yourself, or do you want me to see if you qualify?
If I qualify, Your Honor.
Okay. Okay, ma'am, you do qualify for the appointment of a lawyer.
Yes, Your Honor.
I'm going to appoint a lawyer to represent you. Do
Okay.
you have any questions for me?
Your Honor, I was gonna ask, like, you said my total bond, so is that for the two charges?
Yes, ma'am.
That's total for the two charges?
Yes, ma'am. But I will advise you that the sheriff's department is required to add fees to the bond that I am not to. So it'll be a little bit more, but I don't know what number that will be, but it will be a little bit more.
Okay.
Okay?
I can go through a bonding company.
Yes, ma'am. You can go through a bonding company. You can put the whole amount up as cash, or you can use property.
So what I'm trying to understand, Your Honor, is like, is it 10% of what my bond is?
That's generally the amount, but because I don't work for the bonding companies, I don't like tell people it's X amount.
Okay.
So the bonding companies that are setting or allowed or to set bonds or to come in and to pay for bonds for people here, they have differing rates.
Right.
So you would have to call each one to kind of price, basically.
Okay.
So it's like, it's like a dealership or a car. Same car, different dealerships may charge you different rates. So that's the thing that I would encourage you to do.
Yes, sir.
Any other questions?
No, Your Honor, that was all.
Okay, you're free to go back, man.
Okay, thank you.
You're welcome.
Next one is Griffin.
Good morning, Your Honor.
Good morning. Ms. Griffin, you've been charged with one count of reckless conduct. I'm going to set the bond at $1,500 for that.
Okay.
Do you believe you can post that bond, ma'am?
Yes, sir.
You're going to have a preliminary hearing date that's going to be set for April 6th at 8:30 in the morning, but that date is going to get waived upon your bonding out.
Okay.
Do you plan on hiring your own lawyer representing yourself, or do you want me to see if you qualify for the appointment of a lawyer?
See if I qualify for,
Okay. Give me 1 second.
okay.
Okay, you're at the edge, ma'am, but you do qualify for the appointment of a lawyer.
Okay.
I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir.
Okay, you're free to go back.
Next one is Holloway. Good morning.
Good morning. Holloway, you've been charged with one count of disorderly conduct. The bond is set at $1,500 for that. Do you believe you can post that bond, ma'am?
Yes.
You're going to have a preliminary hearing date set for April 6th. That date is going to get waived upon your bonding out. Do you plan on hiring your own lawyer, representing yourself? Or do you want me to see if you qualify for the appointment of a lawyer?
You can see if I qualify for it.
Okay. Are you currently employed, Ms. Holloway?
I was until yesterday.
Okay. So you qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir.
Okay. You're free to go back, ma'am.
Thank you. Next one is Johnson.
Ms. Johnson,
Yes.
you've been charged one count of criminal trespass and one count of hindering an emergency phone call. I'm gonna set your total bond at $5,000, $2,500 for each count. Do you believe you can post that bond, ma'am?
I don't know. Can you take a debit card?
Well, the best way that I can explain it is this. Bonding companies will take any forms of payment.
I'll be able to do that, but they told me I can leave, but they didn't tell me what day. Will I be able to leave after everything's finished?
Wait, could you repeat that? I didn't understand it.
Will I be able to leave? They said I'll be able to leave. Will I be able to leave? They said something about me having court today, but will I be able to leave today too? They told me to ask why, when I have court.
So if you post bond today, you will be able to leave jail today.
Okay. Okay.
You're gonna have a preliminary hearing date set for April 6th, but that date is gonna get waived upon your bonding out.
What's the April 6th for?
The preliminary hearing is a hearing to determine or to inquire into your arrest and whether there is probable cause for you to have been arrested. And as I said in the script that I was reading before, the standard is really low. It's not whether you're guilty or innocent. It's just whether the crime possibly could have occurred. But if you bond out, your case will get sent to the Solicitor General's office.
Okay.
And that's the office that will ultimately prosecute your case. So at some point, you'll get a new notice as to you need to come to court. But it won't be April 6th. It'll be sometime out into the future.
And what's the court for? What is the court saying after that?
I'm sorry, you said what is the court?
What is the court saying after April the 6th? What's going on with the court after April the 6th? What's going on with the court after April the 6th? You said Father.
Yes. So because of all of the COVID times in the pandemic and everything that's going on, there's nothing that's happening quickly.
Okay.
So it's gonna be a date sometime in the future.
What's it for? What's it for? What's the other court for? After COVID and all that.
It'll be to determine whether you should be found guilty or innocent.
Okay. Okay.
Okay. So, do you plan on hiring your own lawyer, or do you want me to see if you qualify for the appointment of a lawyer?
Well, I'd rather go ahead and do what I need to do. You have to pay this bond. Why having another court date?
You said, why do you have another court date?
Yeah, if I pay the bond, why would I have another court date?
Okay, so this process, ma'am, is basically like if you compare it to being at a doctor's office, this hearing is you've walked into the door of the doctor's office and you haven't even signed your name on the form saying that you're there.
What are you talking about?
I'm sorry, ma'am. I'm trying to understand.
What are you talking about, Dr. Office?
Your question was, what is the next?
What are you talking about, a doctor office?
I'm trying to give you an analogy so that you can understand, because you asked the question of about the next court date and why do you need another court date?
Yeah, after I pay the bond.
Okay. What I'm going to ask you to do, ma'am, is just try to understand what I'm saying to you. Okay? Can you do that?
Okay.
So you have been arrested and charged with a crime. This is not a trial. I'm not here to tell you whether you're guilty or innocent.
Yeah, a bond to be paid out today and I can get out today. What's the next, what's going on with April the 6th? What's going on with April the 6th, sir?
No problem. Yeah.
Okay, can you repeat to me what I told you about April 6th?
You just told me if I pay the bond off today, I'll leave today. What's going on with April the 6th? I need to know.
Can you repeat to me what I told you about April 6th?
You just say if I pay off the bond I have today, I'll be able to leave. I need to know what's going on with April the 6th.
Okay, so ma'am, that's not what I told you. What I told you is that the April 6th date is a preliminary hearing date that will get waived if you bond out. Can you repeat that to me?
April the 6th will be a waived bond.
That's not what I said. I want you to repeat the whole thing.
I just heard what you said. I need to know if I'm...
Ma'am, can you repeat what I just asked you to repeat to me?
Can you say it again?
Judge, we'll take care of it. Come on, man.
Okay, you're free to go back, ma'am.
Kerbo Baines. This is Kerbo Baines.
Okay.
Go sit in the back.
Good morning, Your Honor.
Good morning. Can you spell your last name for me?
KERBO-BAYNES.
Okay. Now, you've been charged with one count of violation of Georgia Controlled Substance Act, which is possession of a controlled substance. I'm going to set the bond at $3,000 for that. You've been also charged with possession of drug-related objects. I'm going to set the bond at $1,500 for that. So that's a total bond of $4,500. Do you believe you can post that bond, ma'am?
Yes, sir.
Do you plan on hiring your own lawyer representing yourself?
Yes, sir.
Oh, I'm sorry. I asked you like a multi-tiered question. So you're going to hire your own lawyer?
Yes, sir.
Okay. You're going to have a preliminary hearing date that's going to be set for April 7th. That date is going to get waived upon your bonding out. Do you have any questions of me, ma'am?
No, sir.
Okay. You're free to go back.
Thank you.
You're welcome.
Next is Ms. Meeks.
Good morning.
Good morning, Ms. Meeks. You've been charged with one count of possession of marijuana less than an ounce. The bond is going to be set by schedule at $1,500. Do you believe you can post that bond?
No, sir.
Okay. I would encourage you, ma'am, to contact the bonding companies that are authorized to write bonds here in Clayton County, because they will work with you in order for you to be able to bond out. You're going to have a preliminary hearing date that's going to be set for April 6th, but the date will be waived upon your bonding out. Do you want me to see if you qualify for the appointment of a lawyer?
Please.
Okay. Okay, ma'am, you do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir.
Okay, you're free to go back, ma'am.
Next is Ms. O'Glennis.
Good morning.
Good morning, ma'am. Sorry, I got paper that I got to deal with over here. Would you spell your last name for me?
It's Obleanis.
Hey, Your Honor, sorry for interrupting. I have Ms. Bush. Whenever you're ready.
Hey, I was gonna ask about that at the end, but we can deal with her next if you want to.
Okay, that's fine.
Okay. So, ma'am, you've been charged with one count of affray, which is basically fighting in public. The bond is set at $1,000 for that. Do you believe you can post that bond?
Yes.
Okay. Do you plan on hiring your own lawyer representing yourself, or do you want me to see if you qualify for the appointment of a lawyer?
You can see if I qualify.
Okay. Approximately how much do you make per month?
It varies, but
You can tell me per hour?
I get paid $18.80.
Okay. you qualify, ma'am. I'm going to appoint a lawyer to represent you. You're going to have a preliminary hearing date set for April 6th, but that date is going to get waived upon your finding out. Do you have any questions?
No, sir.
Okay, you're free to go back. Are you Miss Bush?
Yes, sir.
Ma'am, you've been charged with 1 count of battery. The bond is going to be set at $5,000. Do you believe you can post that bond?
Yeah.
There's going to be a stay away provision on your bond to stay away from Kendrick Reynolds.
Okay.
Do you plan on hiring your own lawyer representing yourself, or do you want me to see if you qualify for the appointment of a lawyer?
Yeah, you can see if I qualify.
Okay. About how much do you make per month?
Oh, right now I'm on leave of absence. I've been on leave of absence since November.
Okay. I'm going to find that you qualify. I'm going to appoint a lawyer to represent you. You're going to have a preliminary hearing date that's going to be set for April 6th, but that date is going to get waived upon your bonding out, and you'll get a new court date in the mail.
Okay. Yes,
Do
sir.
you have any questions of me, ma'am?
Not about this. I got another one. Do you have the one about the ticket I got?
I'm sorry.
Do you have the case about the ticket I got?
The only charge I have before me is a battery charge. So I don't have anything related to a ticket.
How would that work? Because we live together and everything, and he's picking me up if I get out today.
So the stay away provision can be lifted if he says, he contacts the Solicitor General's office, Clayton County Solicitor General, and says, look, I'm not afraid of her. I don't have any problems. When these types of charges come before us, we place a stay away provision because we don't want whatever caused you to come before me to happen like tonight, flare back up. So if he has no problems with you, he can just contact them and that provision can be lifted.
Okay.
Okay?
Yes, sir.
Do you have any other questions, ma'am?
Will I get out today if I post the bond?
Yes, ma'am.
That's all.
That's it? Okay. All right. You're well, I was gonna say you're free to go back, but we're done with Miss Bush.
All right, Your Honor, next we have Ms. Smith.
Good morning, Judge.
Good morning, Ms. Smith. You've been charged with a number of drug-related offenses, and they're all felonies.
Just because of my house.
I am gonna set a total bond. Sorry, got it. I'm going to set a total bond, ma'am, of $23,000. Do you believe you can post that bond?
Not really, because I just got out of jail for them coming to my house, and I paid my rent money to get that out. And the other people that were in my house, they got arrested for these same charges. So I don't understand why I'm getting charged with their stuff.
The warrants were sworn out on February 13th, and
Right.
the allegation is that on February 11th is when these instances occurred.
Mhm.
So I'm setting a bond of $5,000 for each offense that's alleged in the warrants. So there are 1, 2, 3, 6. There's six different charges.
Right, but those charges were placed on me after the incident happened, and those charges were also placed on the people who were arrested, my child's father and my babysitter. Those drugs were on them, and he said that those were his drugs. And I was told by the officers that I wouldn't be charged with their stuff. And then when I came up here to get my car, they arrested me.
Yeah, there's what I can do, ma'am, is I can appoint a lawyer to represent you to hopefully get these charges dismissed.
Right, can you give me like a smaller bun so I can get to my 2-year-old daughter? Because as I said, I came up to the jail just to get my car get the release papers for my car. And my baby is somewhere that, I didn't want her to be there for longer than a day. You get what I'm saying? And I wasn't expecting to come back into jail.
No, I do understand.
I'm just saying, could you be a little bit more lenient with that bond? Because I just bonded out for what I did. I had a theft by receiving charge in DeKalb County. That is why they originally came to my house. I don't feel it was my fault that, I'm charged with something that these people had on them. These were their stuff. This was their drugs, not mine. I go to work and I come home.
What I've done is I actually set your bond at half the amount that I normally set for these allegations.
Yes, sir.
And so the problem that I have in this circumstance is that I have to accept what is written down as being true. And I have to accept what you're telling me as being true. And then try to figure out kind of the way in the middle.
It's bad how they did me. Yeah, I was told that I wouldn't be charged with those charges. And then when I came up here to get my car, they threw the charges on me. Charges that other people already accept accountability for. It's not fair.
Oh, sorry. Give me 1 second. All right. Let me look at this. Like I said, I take what you're telling me as being true. So I'm looking.
Yes, sir.
This trying to reconsider.
Please. And thank you so much for hearing me out. Appreciate it.
Ma'am, that's what I get paid to do.
Thank you. Yes, sir. They charged me with drugs that they found she had drugs in her private area. They put that on me. How could they have been mine? How could I have known that she had it? It's unfair.
I do recall this. I think this case, because of the Brookhaven search warrant.
Right. But that's by receiving. That's why I went to the cap, and Clayton told me that I wasn't charged with any of that because my child's father told them that the rest, everything else was his. He told them that, and they told me they weren't going to charge. And then they also told me they weren't going to tow my car because I asked to get my license out of it. And they did. They told me, oh, we're not towing your car. Then when I got out of the DeKalb County jail and got home, they had towed my car out of my garage at my house. The car was towed out of my garage. Like, ever since I've had a daughter, I don't get in trouble anymore. I don't. I know how Clayton County is. They have roadblocks right there by my house every other day. So I don't play with them. Like, I called and asked could I get my car. I come to pick up the release for my car and they lock me up. It's really, really, really unfair. When I know why am I being charged with someone else's drugs?
Okay, I'm gonna set your bond at $13,500.
Thank you.
Do you plan on hiring your own lawyer, representing yourself, or you need to see if you qualify for the appointment of a lawyer?
You can see if I qualify, just in case I'm not employed my own lawyer like I thought I would be, because I got to find out now.
Okay, you do qualify, ma'am. I'm going to set a appointed lawyer to represent you. You're going to have a preliminary hearing date that's going to be set for April 7th. And that date will be waived upon your bonding out. Do you have any other questions of me, ma'am?
No, thank you. I appreciate that.
Okay, you're free to go back.
Next gonna be Ms. Settles.
Ma'am, you have one count of terrorist threats and one count of aggravated assault.
Good morning, Your Honor. I have never been in this jailhouse. I'm a student, a senior citizen, trying to get my barber's license. I have a rebellion child that is on drugs at home. I begged the officer, would you allow me to pay 30 days and not put my child in the cold? I have an elderly mother that has Alzheimer's, just lost her hair, and you running in and out in this COVID-19. And Your Honor, I said to the officer, I said, and the dog, a big bulldog, I have a Pomeranian, and my daughter's deployed, coming home today from nursing near California. And this big bulldog, I had to put my Pomeranian outside because you totally took control of the house. And this is what the drugs do. I want to save my daughter, Your Honor. This is my child. I didn't want to do anything. I didn't put my hand on it.
This ain't time to plead.
Your Honor, I did not have no intentions. I called the police. If I wanted to hurt my daughter, it would have happened long before now. I called for peace in the neighborhood, and it turned into something much more than it shouldn't have. The officer had left and then came back.
Man, let the judge finish, and then your lady talk. Let them go through the process.
Yes, sir, I will. I do apologize, sir.
No, Miss Settles, I did notice that there was kind of a difference in the warrant than what I normally see. And for someone charged with aggravated assault, normally they're not getting bond at this stage. But I looked at your history, and I'm giving you a bond of $2,500 for the aggravated assault and $2,500 for the terroristic threats. So that's a total bond of $5,000. Because this is a felony charge, you're going to have a preliminary hearing date that's going to be set for April 7th. And that date will be waived upon your bonding out. Now, do you plan on hiring your own lawyer or representing yourself? You want me to see if you qualify for the appointment of a lawyer?
Your Honor, I will have to qualify. I'm on fixed income. They took my Social Security because I had a vehicle that's a little bit more. Cut my Social Security out, so I'm on a limited income. If you could lower that bond, and I have the opportunity to call down to Lamar to Miss Portia, the bondman, and have her the opportunity to try to bond me out, sir.
I'm gonna keep the bond set at the level that it is, because like I said before, I normally don't set bond on this charge. So you said you're currently, is it retirement that you're receiving?
Yes, sir. I'm on total disability. Matter of fact, I told the officer I'm up on the doctor's care as we speak. I got hurt on my job, so I'm under doctor's care. And matter of fact, I'm on medication, and I haven't had any since the time I was arrested. High blood pressure, sugar, diabetes, and many things right now.
Okay, so I'm gonna appoint a lawyer to represent you. And like I said before, you're gonna have that date for April 7th, and it will get waived upon your bonding out. Do you have any other questions for me?
No, sir. I just want to know, can I have the opportunity to use the phone to call home, sir?
Yes, you will get that opportunity after this process is over.
Your Honor, with all due respect and mercy on the court, once I called to get that bond, I have not yet had my medicine last night. I know there's a process and procedure, and I'm asking that maybe once they put that bond so that I can get home, because I'm feeling very ill.
I'll talk to the joint officer before you have nurse come down here to check you out, okay?
Yes, and they will work with you. The staff is very capable, and they will help you out.
Thank you, Your Honor. Have a blessed and great day.
You too.
Thank you, sir.
I got you. I'll talk to the joint officer.
Thank you, Chief.
Yes, ma'am.
Can I leave my
Yes, sir, you can. Last one is Ms. Webster.
Your Honor.
Good morning, Ms. Webster. You've been charged with one count of battery. The bond is going to be set at $5,000 for that. Do you believe you can post that bond?
That's for domestic violence?
Yes, ma'am.
Yes, sir.
There's also going to be a stay away provision to stay away from Craig Webster. And I believe that he was arrested also.
Yes, sir.
And there's going to be a stay away provision that's going to be placed on him to stay away from you. And he's going to get the same bond amount. The stay away provision can be changed. but it's going to be something that both of you are going to have to contact the Solicitor General's office and let them know that you're not afraid of the other person. And just so you understand, the reason that that happens is that we don't know you, we don't know Mr. Webster, we don't know if this was just an argument that got out of control, or this was something that the police authorities arrived right before somebody was stabbed or shot or anything like that. Okay. So we take the approach that is the worser part, because you can always go down. But if we take it as being, this was just an argument, and then the two of you go home, and tonight somebody's shot or killed or stabbed, it becomes more of a problem. So I hope you understand that explanation.
I do.
Okay. So, do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay, ma'am, it looks like you qualify. I'm going to appoint a lawyer to represent you. You're going to have a preliminary hearing date set for April 6th, but that date is going to get waived upon your bonding out. Do you have any questions for me?
Yes, sir. Is this a misdemeanor?
Yes, ma'am.
I just thought it was a bit high for a misdemeanor.
That actually is the starting amount for this offense. Any other questions?
No, sir.
Okay, you're free to go back.
Thank you.
Okay, y'all, that's it for the females.
Okay, you enjoy the rest of your day.
Yes, sir, you too.
Have your name, sir?
Stevie Cortez Bland.
Okay, Mr. Bland, you've been charged with 1 count of battery and 1 count of aggravated assault. The bond is going to be denied at this point on the aggravated assault. I've set a bond at $5,000 for the battery offense. You're going to have a preliminary hearing date that's going to be set for April 7th. And you're going to have a bond hearing date that's going to be set for April 2nd. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify, Mr. Bland. I'm going to appoint a lawyer to represent you. Do you have any questions of me, sir?
No, sir.
Okay, you're free to go back. Your name, sir?
Joe West Calhoun.
Mr. Calhoun, you've been charged with several driving related offenses. UI, alcohol, less safe. Bond's going to be set at $5,000. Fleeing from an officer, the bond's going to be set at $1,000. There's a red light violation, which basically means you ran a red light. Bond is going to be set at $500. An open container violation, bond is also going to be set at $500. And looks like it's obstructing or hindering the display of license, which basically means there was or tag, which basically means like your tag was somehow obstructed.
Yes, sir. My baby mother has, it's just a cover over it, a clear cover.
Okay. The bond for that is $500. So you're going to have a total bond of $8,500. Do you believe you can post that bond, sir?
No, sir. I was actually wondering if with the traffic offenses such as the open container, the tag covering, and the red light, if I could OR bond on those, if that's available.
Not at this stage. That's something that we are working on and we may deal with later, but currently we are not doing OR bonds. So you're going to have to post a bond for those offenses.
$8,000 total.
Yes.
All right.
You want me to see if you qualify for the appointment of lawyer?
Sure. Yes, sir.
Okay. It looks like you do qualify, Mr. Calhoun. So I'm going to appoint a lawyer to represent you. You're going to have a preliminary hearing date set for April 6th, but that date is going to get waived upon your bonding out. So do you have any questions for me based upon what I just told you?
None other than, is there any way we can make the bond lower?
I wish there's a minimal amount that's set. So the biggest one is the DUI, and the minimum amount that's set is $5,000.
But the thing about DUI, I mean, not to question your officers or anything, but your officer stated that being as the open container was in there, I asked him if I could take a breathalyzer right then and there. He refused to let me take a breathalyzer. He instead wanted to wait for me to get to the hospital to take a blood test, in which I'm pretty sure no alcohol whatsoever showed up in the blood test. But I mean, of course, we're not here to settle cases right now. But the fleeing and that whatnot as well, I don't like. What is the bond on that as well?
For the fleeing, it was $2,000.
And for the DUI, it's $5,000.
Yes.
So there's absolutely no way possible whatsoever that we can lower this bond.
Well, I'll tell you what. I can drop the fleeing down to $1,000. So
$7,000.
Yes, I can cut that in half. But with the DUI, that's sort of like a policy that I would have to get it from my office.
The open container, that is a ticket in and of itself. Am I correct?
Generally, it is. I mean, the problem, I think that what you have encountered is that the DUI is something that is not a ticket offense.
Yes, sir.
And the fleeing is not a ticket offense. So everything else that you've been charged with, those are offenses that you can get a ticket and go about your way. But once you get wrapped up in the sort of the other stuff, it kind of gets piled on.
The portion of being arrested, is that what you're saying?
Yes, sir.
Okay.
And so my appointing a lawyer to represent you, hopefully the lawyer will be able to work this stuff out and get it taken care of. But that's kind of, that's the boat. And, and I tell people a lot of times, unfortunately, officers have the discretion for most offenses, to driving related offenses, to give you a ticket, arrest you.
Oh, this one didn't have much.
Yeah, and once you get arrested, you're kind of on the ride.
Understandable.
Okay. Anything else, Mr. Calhoun?
No, sir. I appreciate your help.
Okay, you're free to go back. Tell me your name, sir.
Richard Frazier.
And that was Frazier, Frazier?
Yes, sir.
Okay. Sir, you've been charged with a number of driving related offenses. 2 fast for conditions, and says having are you still there?
Yes.
Okay. Having a expired tag. Both of those offenses, the bond is set at $500 each. No insurance, the bond is set at $1,000, and driving on a suspended license, the bond is set at $1,500. You have a total bond of $3,500. Can you post that bond, Mr. Frazier?
Yes, sir. Now I have one question, sir.
Yes, sir.
For the driving too fast for conditions charge, I wasn't even told the speed of which I was going, or neither was it put on the ticket. So, what is considered driving too fast for conditions?
That is a totally subjective kind of charge, and it's something that you would have to kind of deal with what we legal community call a trier of fact.
Mm-hmm.
And that is either a jury or a judge. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify, Mr. Frazier. So I'm going to appoint a lawyer to represent you. And you need to tell the lawyer exactly what you just told me.
Yes, sir.
You're going to have a preliminary hearing date that's going to be set for April 6th, but that date is going to get waived upon your bonding out.
Okay. And you said my bond once again is what?
Let's see. $3,500.
$3,500. All right.
All right. You're free to go back, Mr. Frazier.
Yes, sir. Thank you.
You're welcome.
John,
Yes.
I have 3 medical guys over here with me.
Okay.
I had DeGaulle, Floyd, and Johnson over here with me.
Did you say DeBro?
Yes, you said Floyd?
You said the first one, was it DeBro,
yes.
Floyd and Johnson?
Yeah, Johnson and, no, not Ford. It's Ford, not Floyd. Ford.
Okay.
Ford. And I have Johnson and DeGaulle.
Okay.
Those 3 over here with me.
Okay. We can do them right now.
Okay. Well, I had to go up on.
Okay, Mr. DeBro.
Yes, sir.
You're charged with aggravated assault and battery. The bond is going to be denied on the aggravated assault charge at this stage. But I'm going to give you a preliminary hearing date of April 7th and a bond hearing date of April 2nd. It looks like you may qualify for the appointment of a lawyer. Do you want me to see if you qualify, or are you going to hire your own lawyer?
As by the bail, was it not?
I'm sorry.
I said, can I ask why my bail was denied? Why I can't get no bail?
Your bail is being denied on the aggravated assault by strangulation charge because of the allegation. You're getting a bond on the battery, but not the aggravated assault because the allegation is that you essentially strangled someone almost to unconsciousness.
Got shot. She shot. I never had a chance to tell my side of the story. I would never ask. I'm not from out here. You know what I mean? I never knew I had to make a statement to ego up with that statement. They never told me that. They told me I wasn't charged with nothing when I asked. So I never said nothing until I got to the hospital. That's when they told me I was charged. So they only went off of what she said. I never had a chance to say my side at all. I didn't know. Like they were telling me I wasn't going to be charged. I was shot. She shot me.
There is, do you want me to appoint a lawyer to represent you? I can do that.
Yeah, that's why I thought I was going to get one for this burial here and somebody was going to talk on my behalf. I thought I was going to have a public defender right here or somebody right here talking on my behalf. You know what I mean? Because I never had a chance to say my side. The true side, they only got her side and went off of that and let her go and lock me up in the hospital. I never had a chance to say my side of the story. They just went off of what she said. I had a gun in my head. I thought I already died last night. I got shot, sir. I got shot.
No, and that's an unfortunate thing, and we're trying to change that now to hopefully have lawyers at this stage, so that as a judge I can hear both sides and kind of make a better understanding. But the allegation, I take what you're telling me as 100% truth.
I'm just asking for a chance. Like, I just came out here in Georgia. I'm not from out here. I just moved my daughters out here. I'm a single father, man. My kids, their mother, they gone. Like, I take care of my kids, man. I don't. If I say hey, I don't know where they gonna go back. I don't got nobody out here. I'm losing my job. I'm losing my house. I'm losing everything I got. I came out here just to stay out of trouble. I came out here just to change. I came out here for a better life. I left a whole nother city just to change. They never got me out of the store.
And I understand that. And the problem that I have, or the disadvantage that I'm placed in, is that I can't like ask probing questions of both sides. And the allegation right now is that you strangled a person. And so that's something that I have to say, okay, that's going to have to be looked at. And it's not like you and I talking about it. It's meaning like both sides being able to discuss it. So I can appoint a lawyer to represent you.
I understand. I just want a fair chance. I just want a fair chance. I'm not a fight risk. Don't got no record out here. I don't get in trouble. You know what I mean? I just want a fair chance. But I just want a bail, please, man. I need to get home to my kids, man.
No, I do, but I'm not gonna remove the no bond provision on the aggravated assault charge.
You mean to tell me I could shoot somebody and make up a story? They let me go and lock them up, and I could get away with that. That's what go on down Georgia now. You can just shoot people, and whatever they say, they just gonna go with it. I mean, that's what it's saying. Like that's what the situation was.
At this stage, yes. Unfortunately, yes.
Oh man, that's unbelievable, man.
Do you want me to appoint a lawyer to represent?
Yes, sir.
Okay. I'm going to appoint a lawyer to represent you. And I hear what you're saying, and don't let me leave this with you're not understanding that. But I can't, because and I'll say this, I have people who they don't know that I have access to their criminal histories, and they'll say, I've never been through this before. I don't know what's going on. And I know that they've been arrested 15 times. So I can't just rely upon what you're telling me. at this stage, but I've done what I can do to help you. To kind of move past it.
That's not help me. Like, help me, give me. It could be a high bro. This help me. If I got kids, I'm gonna lose my kids. I don't care about my job. I don't care about the house. I'm gonna lose my kids, man. They don't got no mother. She died a few years ago in the car. I take care of my kids by myself. That's all I'm asking, just for some help. Like I said, they heard her side. I'm not disputing what she said, whatever. They heard her side. I never knew. I could tell my side. I just said I didn't want to talk. I'm bleeding in the back of the car. I just wanted to go to the hospital. I was bleeding. I never had a chance to tell my side. Now I'm sitting here with a no bail. Still with a no bail. That's not fair. That's not fair. That's not giving me a chance. That's not fair. I feel like it's not fair, man. I mean, I understand you got your job. I understand you going off with what you got. I understand it. I understand. I'm not disputing that. I understand that. You know what I mean? But tell me, I got my kids. I'm just worried about my kids. Like, I'm not worried about the job. I'm not worried about my house. I'm not worried about my car. I'm just worried about my kids. I don't got nobody to take them if I go to jail. Right now, my neighbor got them. But that's it. I got shot. I had a gun in my head. Like I said, I never had my chance to tell my side of the story. Never. I didn't know I had to tell my story. The police told me yesterday, being that I didn't say what happened, and she said what happened, they're going on for her. And that's just what's going on. He said, because I didn't say nothing. I didn't know that. I was never told that. I'm not from out here. I didn't know that. I didn't know that.
There is what I'll say to you is this. Within the next day or two, contact the Clayton County Public Defender's Office, because they're the people that are going to be representing you, and tell them what is going on in your case. And like I said before, I don't have a situation where I can deal with it right now. So that's kind of the best thing that I can do for you.
Oh, bail, how that's the best thing. I mean, I can't even work nothing out. That's not how that's the best thing. I mean, I'm stuck. That's not how that's the best thing, man. Like, I can't believe this, man. I didn't come out here for this. I left a whole nother state to come out here for. I didn't come out here for this. I really did.
Oh, I mean, okay. I mean, all I can say is that the person who's the alleged victim is the person that's doing this to you. And if she's lying about it, she's lying about it. And that's something that you can work out on the back end. But I gotta do what I gotta do.
All right, you want to you ready for the second one?
Yes.
It's forward.
Mr. Ford, you've also been charged with aggravated assault by strangulation, family violence, battery, and cruelty to children. Those are the charges.
Yes. Do I have the opportunity to tell my side, or because I didn't honestly, I didn't put my hands on nobody at all. Like nobody. We was outside. She grabbed me by my neck. I was putting my bag in my car. She walked up behind me, grabbed me by my neck. I fell back on the ground. She was on top of me. Like, I didn't hit her. I didn't choke her. I didn't do nothing to no child. I didn't do nothing around no child. Like, we was literally outside. I even have text messages to prove that I didn't strangle her, I didn't hit her, none of that. Like, in my phone, she texted me the same day because the detective called me. They saying that I shouldn't have left, right? But she didn't call the police till 2 hours later. She texted me. Yeah, because we started talking. You know what I'm saying? Then her detective ended up calling me. The detective tell me, he says, this was the next day. He tells me to come up here because she didn't want to press charges. You know, everything, just come up here and fill out my side of the story. When I get here, I'm getting locked up. But I got text to prove that I didn't hit her, I didn't choke her, I ain't do nothing to no kid. I was outside. Like, I went in the house, got my bag, started putting my bag in my truck, she came up behind me and grabbed me by my neck, man. And I was like, right now,
Mr. Ford, would you like me to appoint a lawyer to represent you?
Yes.
Okay.
Yes, Warren.
So I don't
want to appoint a lawyer to represent you, but at this stage, you're going to get a $5,000 bond on the battery charge.
Okay.
$5,000 bond on the cruelty to children charge.
Mm-hmm.
The bond is going to be denied on the aggravated assault by strangulation charge.
Off the wall.
So
okay, I hear you.
The lawyer will be able to advocate for you on your behalf, okay? But based upon what I have in my warrants, I'm not inclined to grant a bond on aggravated assault by strangulation charge.
But I didn't strangle her. Like, I really didn't put my hands on her at all, man. She came behind me and grabbed me by my wrist is fractured. The only reason why I don't have a brace on is because they took it off when I came in here. I can't even hardly use my hand. Like, I ain't lying. It's swollen. You can see it's bigger than the other one. Like,
Mr. Ford.
Yes, sir.
Like I've said before, and I don't know if you heard, but it's like I have to take everything as being true. Okay. And that's why this isn't a trial. I take everything that the information I'm being given is true, and then I have to make decisions based upon it.
So how long like sit in?
So, Mr. Ford, if what you're telling me is true, you shouldn't be sitting here long because is not telling the truth. So those are steps that are beyond me at this stage. I don't know her. I've never met her. I can't make any determinations about it.
So like you say, I don't get no bond for the strangulation. So that means like I can't get out, right?
Yes, sir.
Okay, so that's what I'm saying. What I got to do? Wait for another court date or something?
You don't have to wait to another court date. Although I've set court dates for April 7th and April 2nd. But this can get resolved if what you're saying is true. It can get resolved within a couple days.
How can I get? That's what I'm saying. How can I get it resolved though? I don't understand. You know what I'm saying? What can I do to get? I own a business that I'm.
Okay, so Mr. Ford, I don't know the alleged victim in this case. This is somebody that you know, and this is somebody that you have chosen to associate with, and this is someone that you have chosen to associate with. That based upon what you're telling me, she has lied about you to get you arrested, right? Yep. Those are decisions that you made, and I can't do anything about that.
Yep.
What I can do is appoint a lawyer to represent you, to advocate on your behalf. I can tell you that if this gets worked out, you can get released. But the charge of aggravated assault by strangulation is not a charge that I, as a judge, will just release a person back on the street.
Yes, sir.
Okay?
Yeah,
so imagine if it's your daughter.
Okay, so what if you get...
Wait.
Go ahead.
So your daughter, her boyfriend is alleged to choke her out. And the judge says, oh, okay, he can go back out on the street. Most fathers would say,
Your Honor.
Where did that go?
Your Honor, how you doing? Okay, come on.
Yes, I apologize. Apparently, the computer was not plugged in and it died. So, Mr. Ford.
Yes, sir.
We have a preliminary hearing date that's going to be set for April 7th. And you're going to have a bond hearing date set for April 2nd. If what you're telling me is true, this case will be resolved before those dates ever happen. Okay? I can't have like I said, have a trial here. I have to go upon what is in the affidavits with the warrants from the police officers. And in this case, they actually came and got warrants before a judge. So did I appoint a lawyer to represent you?
No, I don't think so, but I need one.
Okay. I'm appointing a lawyer to represent you. You do qualify.
Okay.
But that's it, sir. I'm sorry, but that's kind of where we are.
All right.
Thank you, Your Honor.
Can I ask a question?
Yes.
So is there anything I can do on my behalf to speed up the process?
So contact today is Friday, but I guess by Monday, contact the public defender's office.
Mm-hmm.
Let them know the information that you have relative to your case. And that should be something that should speed this process up.
All right, man.
Okay. You're free to go back.
No, you come on.
You good?
Okay, thank you.
Go ahead, thanks, my chairman.
You're Mr. Johnson?
Yes, sir. That's just down the wall.
Mr. Johnson, you've been charged with one count of criminal trespass and one count of false imprisonment.
False imprisonment?
Yes. Do you want me to explain the charge to you?
Yes, sir. False imprisonment.
Well, falls into it.
Okay, so both counts involve the same person.
The same person. Whoa. I'm just calling for myself, bro. I'm calling what these folks got me up with. What these folks.
I got you. Just okay.
Yeah, cause ain't no fun.
The judge is talking and waiting for you to finish.
Yes, sir.
So, Mr. Johnson, you realize that neither me nor the deputies that you're dealing with now.
I'm not you know say that. I'm just asking you what you were saying, and you asked me to explain to me.
You got to finish that up while the judge is talking, sir. You're making the voice of your case.
Okay, so Mr. Johnson, the allegation is that there is looks like Nakiva Fears.
I don't know no Nakiva Fears, sir. I know an Amber Spurlock that they had supposed to say a warrant was taken out on me for at a Shell gas station.
Okay, so the allegation is that that you interfered with the possession and use of Nakia Fear's iPhone after not finding your car keys. And it says, as she was attempting to exit the home, that you closed the door and blocked her, detaining her in the home without legal authority. And it said that the two of you lived together, and that made it an act of family violence. So does that ring a bell to you?
No, Your Honor, that doesn't ring a bell, Your Honor.
Okay.
But the only thing ring the bell to me, Your Honor, is where you said where you said some keys. All the rest of it, Your Honor, that stuff don't even ring a bell to me.
So let me ask you, Mr. Johnson,
Your Honor.
Yes.
Is that Donald Johnson you reading from?
Quintavious Johnson.
No, he's down here with me. That's Donald Johnson, sir.
Okay. All right. I'm sorry. Okay. You are Donald Zachary Johnson?
Yes, sir.
Okay, I apologize, Mr. Johnson.
I apologize to you, Honor.
So, you've been charged with theft by receiving stolen property and aggravated assault with a deadly weapon. And this is based upon a warrant that was taken out in August of 2020. Does that ring a bell for you?
The theft by a warrant that was taken out for theft by receiving?
Theft by receiving stolen property and aggravated assault.
The theft by receiving, yes, and the warrant that was taken out, supposed to be taken out, yes, I'm familiar with that. This was taken out on the 2nd of the month of 11. It was taken out 11/2.
Yes, sir.
Yes, sir. I'm familiar with this situation, Your Honor. I'm truly is familiar with this situation, but this. Okay. Yes, sir.
Okay, so Mr. Johnson, there's going to be a $2,000 bond set on the theft by receiving stolen property charge.
Yes,
there's going to be a $10,000 bond set on the aggravated assault charge.
Yes, sir.
So there's going to be a total bond of $12,000. Do you believe you can post that?
I don't believe I can post it, Your Honor.
Okay. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir. Yes, sir. Yes, sir.
Okay.
So 10,000. 10,000. That's 1,000, right? And the other 2,200, right? I'm gonna get those off. 13,000.
Okay, Mr. Johnson, you do qualify. I'm going to appoint a lawyer to represent you. You are going to have those dates of April, well, the date of April 7th as a preliminary hearing, but that date is going to be waived upon your bonding out. Do you have any questions of me, Mr. Johnson?
I ain't trying to waive my preliminary hearing, Your Honor. I'm trying to have my preliminary hearing, sir. Because it's some things, it's some things on my behalf, Your Honor, that can really help me with this aggravated assault charge, sir. So I'm trying to have a preliminary hearing. I don't know if that's going to be a good thing on my behalf. I don't know if it's going to be a bad thing, Your Honor. But some things that can happen in that preliminary hearing can prove that all this with this aggravated assault charge, Your Honor, it could prove some things that could be dropped at the hearing pertaining to the situation with me and the girl, who the charges are laid out on me for, Your Honor. I have a lot of things that can prove that, you know, this is what it was, Your Honor. So if it's gonna waive my preliminary hearing, I ain't trying to waive my preliminary hearing, sir. I would like to have that hearing.
So, Mr. Johnson, the only way to guarantee your preliminary hearing is to sit in jail until that date. You can petition the court to actually have a preliminary hearing, and it's up to the judge's discretion. It won't be me, but it's up to the judge's discretion whether to have it or not. So that'll be the avenue for you to try to get what you're trying to get, but you'll have to deal with that with your lawyer.
So, but you said you finna waive the hearing. I don't want my hearing waived. I want to have my hearing. Cause it's just a thing. It's some things in the police report, y'all, where this girl said we was staying together. She was saying she was staying at my house. I know you're not here to hear this. You were just here to set me a bond and let me know what's going on, y'all. Yes, sir.
He gave you a preliminary affidavit. It's only waived if you bond yourself up. It's not.
Oh, okay, I didn't know that.
You can, Mr. Johnson, if you want to have that hearing, you can sit in jail until the date of that hearing, and you will have that hearing. If you want to get out of jail, you can get out of jail.
Get out of jail, then the hearing will be waived. Okay, I didn't know. I'm sorry. I'm sorry, y'all.
Okay, you're free to go back, Mr. Johnson.
All right, that's it, John. Thank you.
Okay, thank you.
All right, quiet down, Joe. Quiet down. State your name.
Larry Gibson.
Okay, Mr. Gibson, you are charged with reckless conduct. Bond has been set at $1,000. If you can go set.
Yes, sir.
You're going to have a preliminary hearing date that's going to be set for April 6th, but that date is going to get waived upon your bonding out. Would you like me to see if you qualify for the appointment of a lawyer?
No, sir.
Okay, you're going to hire your own lawyer or represent yourself?
Yeah, I'm representing myself.
Okay. If you don't have any questions of me, Mr. Gibson, you're free to go back.
Yes, sir. Have a good one.
Tell me your name, sir.
Andrew Jerby.
Okay, sir, you've been charged with a number of driving related offenses. Not having a license, the bond is going to be set at $1,000. Theft by taking. Well, actually, give me a second on that. Okay, bond's going to be set at $2,000 for the theft by taking charge. The hit and run, basically leaving the scene of an accident, the bond's going to be set at $3,000 for that. There's driving a motor vehicle. This is not really spelled out, so I gotta go back and look at it. Well, it's driving a motor vehicle knowing that the registration is suspended. The bond is set at $500. Striking a fixed object, bond is set at $1,500. Reckless driving, I'm going to set that bond at $2,000. Improper lane change, the bond is automatically set at $500. And driving a vehicle without insurance, the bond is set at $1,000. So that's going to be a total bond. That's going to be a total bond of, hold on. Gotta add it up. $11,500. Do you believe you can post that bond, sir?
Yes, sir.
Okay. You're going to have a preliminary hearing date that's going to be set for April 6th. The date is going to get waived upon your bonding out. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay. You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, you're free to go back.
Next one is Devin John, y'all.
Good day, sir.
Hello, Mr. John, you've been charged with one count of criminal trespass. I'm going to set the bond at $2,000 for that. Do you believe you can post that bond?
Yes, sir.
Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay, you're on the cusp of it, but I'm going to appoint a lawyer to represent you, Mr. John. You're going to have a preliminary hearing date set for April 6th, but that date is going to get waived upon your bonding out. Do you have any questions of me, Mr. John?
No, sir.
Okay, you're free to go back.
Next one is Montavious Johnson, y'all.
Mr. Johnson, you've been charged with criminal trespass and false imprisonment. I'm going to set your total bond at $5,000. Do you believe you can post that bond?
Yes, sir.
I'm going to put a stay away provision on this bond to stay away from a years.
What do we stay together? What, should have to call up here and do some paperwork or something?
I'm sorry, say that again?
What do we stay together, like the house in both our names? So what, she got to call and do paperwork or something?
She will have to contact the Solicitor General of Clayton County.
Okay.
That's a person that will be able to consent to this stay away provision being lifted.
Okay.
Okay?
Yes, sir.
You're going to have a preliminary hearing date set for April 7th.
Okay.
But that date is going to get waived upon your bonding out.
Okay.
Do you want to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay, you do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions of me, sir?
No, sir.
Okay, you're free to go back.
Next is Jordan, y'all.
Mr. Jordan,
Yes, sir.
you've been charged with one
I
count.
don't see Mr. Jordan in your contacts. Perhaps you met one of these?
Okay, well, that apparently was Siri talking to you. Mr. Jordan, you've been charged with one count of possession of marijuana less than an ounce. The bond is automatically set at $1,500. Do you believe you can post that bond, sir?
Yes, sir.
Okay. You're going to have a preliminary hearing date that's going to be set for April 6th, but that date is going to get waived upon your bonding out. Would you like for me to see if you qualify for the appointment of a lawyer?
Please.
You do qualify, Mr. Jordan. I'm going to appoint a lawyer to represent you. Do you have any questions of me, sir?
Is there any way I could possibly get it a little bit lower or a signature bond?
We're currently not doing signature bonds. This bond amount is set by schedule, and what that means is that there's a panel of people that are above my pay grade that have decided that this is the bond that's going to be set. So I'm not going to lower it. But you know, yeah. Do you have any other questions for me?
No, sir.
Okay, you're free to go back.
Thank you.
Next, Your Honor, is James Lane.
Mr. Lane, you've been charged with 3 offenses. Possession of marijuana, less than an ounce. The bond is going to be set at $1,500. Obstructing an officer, the bond is going to be set at $2,000. And violation of Georgia Controlled Substance Act, bond is going to be set at $5,000. Do you believe you can post this total bond?
Possibly, but I'm not sure.
Okay. You're going to have a preliminary hearing date set for April 7th. That date is going to get waived upon your bonding. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Approximately how much do you make per month, Mr. Lane?
It varies because I do landscaping, so it depends on the weather as well.
Okay. Can you give me like a ballpark, just like an average?
Monthly?
Yes, sir.
Maybe about 2,000, 2,500, something like that.
Okay. You qualify, Mr. Lane. I'm going to appoint a lawyer to represent you. Do you have any questions of me, sir?
Sir.
Okay, you're free to go back.
Next is a Little Young.
Okay, Mr. Little, you've been charged with 4 offenses. The DUI charge is the only one that is not set by schedule. I'm going to set a bond at $5,000 for the DUI. The open container is set by schedule at $500. The failure to dim lights is set by schedule at $500. And the no insurance charge is set at $1,000. So you're going to have a total bond of $7,000. Do you believe you can post that bond, sir?
I think so.
Okay. You're going to have a preliminary hearing date that's going to be set on April 6th, but that date is going to get waived upon your bonding out. Do you want me to see if you qualify for the appointment of a lawyer?
Please do, just in case I don't have a job when I get out of here.
Okay. You do qualify, Mr. Little. I'm going to appoint a lawyer to represent you. Do you have any questions of me, sir?
No, sir.
Okay, you're free to go back.
Thank you.
Next, Your Honor, is Mason.
You are Ronald May?
Mason.
Okay, Mr. May, you've been charged with 1 count.
Mason.
May? Okay. Oh, wow. There's a Ronald May and a Ronald Mason. So, Mr. Mason, you've been charged with several driving-related offenses. And the bond for those are going to be set at a total bond of $3,000. There's a fleeing from a police officer charge that I'm going to set the bond at $2,000. So that's going to be a total bond of $5,000. Do you believe you can post that bond, sir?
Yes, sir.
You're going to have a preliminary hearing date that's going to be set for April 6th. But that date is going to get waived upon your bonding out. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify, Mr. Mason. So I'm going to appoint a lawyer to represent you. Do you have any questions of me, sir?
No, sir.
Okay, you're free to go back.
Next up is Pitts.
How you doing, sir?
How are you, Mr. Pitts?
Pretty good.
So you've been charged with a window tint violation. Bond is set at $500 for that. You've been charged with having a license not on person. Bond is going to be set at $1,000 for that. You've been charged with use or possession of drug-related objects. The bond is set at $1,500 for that. And you've been charged with a violation of Georgia Controlled Substance Act. And that's going to be a felony offense. And the bond is going to be set at $5,000 for that, related to marijuana.
Yes, sir.
You're going to have a preliminary hearing date that's going to be set for April 7th. But that date is going to get waived upon your bonding out. Do you plan on hiring your own lawyer? You want me to see if you qualify for the appointment of a lawyer? You're going to represent yourself.
Could you see if I qualify for a lawyer?
Okay. Okay, Mr. Pitts, you do qualify for the appointment of a lawyer. I'm going to appoint a lawyer to represent you. Do you have any questions of me, sir?
Could you tell me the total amount of my bond?
Yes. $8,000. But
No, I said, okay.
there's going to be a little bit added because Sheriff's Department is required by law to add fees. And I don't have that information before me. But so it's going to be a little bit more than the $8,000.
Okay, that's fine.
Okay. Anything else?
No, sir.
Okay, you're free to go back.
All right, thank you.
This is May,
Okay. Mr. May, you've been charged with 1 count of obstructing an officer and 1 count of use or possession of drug-related objects. The use or possession of drug-related objects charge, the bond is set at $1,500 for that. The obstruction, I'm going to set the bond at $3,000. So we have a total bond of $4,500. Do you believe you can post that bond, sir?
Yes, sir.
Do you plan on hiring your own lawyer representing yourself, or do you want me to see if you qualify for the appointment of a lawyer? I'm sorry.
Excuse me, sir.
Would you like me to see if you qualify for the appointment of a lawyer?
Yes.
Okay, you do qualify. And so I'm going to appoint a lawyer to represent you. You're going to have a preliminary hearing date that's going to be set for April 6th. But that date is going to get waived upon your bonding out. Do you have any questions of me, Mr. May?
No, sir.
Okay, you're free to go back.
This is Mac Adams. How you doing today, sir?
How are you doing?
Great, how are you?
Did you spell your last name for me, sir?
MCADAMS. That's MCADAMS. MCADAMS.
So, Mr. Mike Adams, there is a problem with how things printed out, but it looks like you've been charged with 4 offenses. And reckless driving, the bond is going to be set at $2,000. Driving on a suspended license, the bond is set at $1,500. Possession of marijuana less than an ounce, the bond is set at $1,500. And then possession of a firearm during the commission of a crime, bond is going to be set at $5,000. So that's a total bond. Let's see, 3, 5. Looks like a total bond of $10,000. Do you believe you can post that bond?
Yes, sir. Is no way you can lower it.
I'm sorry?
Is no way the bond can be lowered.
Well, the bond that it's been set has been set at basically the lowest amount for the charged crimes. So that's kind of where it's going to be.
The best it's gonna be.
Yeah.
Okay, I could take that.
Okay. You're going to have a preliminary hearing date that's going to be set for April 7th. And that date is going to get waived upon your bonding out. Do you plan on hiring your own lawyer? You want me to see if you qualify for the appointment of a lawyer, or?
You get me qualified for the appointment on, sir.
Okay. You do qualify, Mr. McAdams, so I'm going to appoint a lawyer to represent you. Do you have any other questions on me?
No, sir, that's it.
Okay, you're free to go back.
Oh, wait, I do have a question, actually.
Yes,
when my folks come to pay the bond, do they come to the jail or they go to the bail bond place?
So if they're going through a bail bondsman, they need to go to the bail bondsman first.
Okay.
And the bail bondsman will contact the jail, and they generally have relationships where they work with people there all the time. So that's generally how it gets done.
Okay.
Anything else?
No, sir, that's it.
Okay, you're free to go back.
Appreciate you. Have a good day.
Next is Eugene Nettles, yeah.
Mr. Nettles, give me 1 second. Get my paperwork together. Mr. Nettles, you've been charged with one offense of possession of marijuana less than an ounce. The bond is set at $1,500 for that. And one count of use or possession of drug-related objects. The bond is set at $1,500 for that also. So that's a total bond of $3,000. Do you believe you can post that bond, sir?
I can post it.
Okay. Do you plan on hiring your own lawyer, representing yourself, or you want me to see if you qualify for the appointment of lawyer?
May see if I qualify.
You do qualify, Mr. Nettles. I'm going to appoint a lawyer to represent you. You're going to have a preliminary hearing date set for April 6th, but that date is going to get waived upon your bonding out.
Thank you.
Have any questions for me, sir?
No, sir. Have a good one.
Okay, you're free to go back.
Next is Leonard Sorrell.
Mr. Sorrells, you've been charged with aggravated assault by strangulation. The bond is going to be denied on that charge at this stage. You've also been charged with battery. You're going to have a $5,000 bond that's going to be set. I'm going to put a stay away provision on your bond to stay away from a Shayna Downing. I'm going to set a preliminary hearing date for April 7th at 8:30 in the morning. I'm also going to set a bond hearing date of April 2nd at 8:30 in the morning. Would you like for me to see if you qualify for the appointment of a lawyer?
You saying I won't be able to bond out, basically?
Not at this stage. But you don't have to sit in jail until those dates that I gave you. You can hire your own lawyer that can contact the district attorney's office, or if you want me to see if you qualify for the appointment of a lawyer, I can appoint a lawyer that will contact the district attorney's office. So
I already have a lawyer.
You do? Who's your lawyer?
I got a lawyer for a previous case that I'll use.
Okay. So contact that lawyer. That lawyer can advocate for your behalf with the district attorney's office.
You said the lawyer can what?
Can speak on your behalf with the district attorney's office. Because of the allegation, bond is not set at this hearing. But the lawyer speaking to the district attorney's office, there can be a better understanding of what took place, both sides, that kind of deal. Okay? Do you have any questions of me, Mr. Suarez?
No, no, sir.
Okay, you're free to go back.
Y'all, do you have a lead? Last name Leap?
I do. I don't have a bond order for him, but I do have paperwork. And I can do a bond order.
Okay, he's coming up.
Fugitive from justice.
Oh, you a fugitive from justice? Oh, well, you don't go last thing, Your Honor. I'll do him last. I don't worry.
Okay. Okay.
The next is going to be Thompson. Yeah, push it.
Are you LaRon?
Yes, sir.
Okay. Sir, you've been charged with driving a vehicle on a suspended license. The bond is set by schedule at $1,500. Obstructing an officer, I'm setting the bond at $2,000. And driving a vehicle without the headlights on, that bond is going to be set at $500.
Okay.
So that's a total bond of $4,000. Do you believe you can post that bond, sir?
Yes, sir.
Okay. Do you plan on hiring your own lawyer, representing yourself? You want me to see if you qualify for the appointment of a lawyer?
Yes, see if I qualify for one, please.
Okay, you do qualify, Mr. Thompson. I'm going to appoint a lawyer to represent you. You're going to have preliminary hearing date that's going to be set for April 6th, but that date is going to get waived upon your bonding out.
Okay.
Excuse me, do you have any questions of me, sir?
No, sir, thank you.
Okay, you're free to go back.
Next is Walker. Anthony.
Mr. Walker.
How you doing, sir?
I'm doing well. You've been charged with 1 count of family violence battery and 1 count of criminal trespass, damage to property. Your total bond is going to be set at $7,500. Do you believe you can post that bond, sir?
No, not at this time. I just had open heart surgery, and I'm not getting the care I need right now, so I'm not working.
Okay. I would encourage you to contact the bonding companies that are authorized to write bonds here in Clayton County. That's their business, is getting people out of jail. They'll work with you.
I'm capable of signing my own bond at this time?
We're not doing OR bonds or signature bonds at this point. So you're going to have to post a bond.
Can you lower it a little bit?
I've set these bonds at the lowest amount that we generally start with for the offenses, so I can't go below that. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
you do qualify, Mr. Walker, I'm going to appoint a lawyer to represent you. You're going to have preliminary hearing dates or a date that's going to be set for April 6th, but that date is going to get waived upon your bonding out, and you'll get a new date in the mail. Do you have any questions of me, sir?
No, sir, I don't.
Okay, you're free to go back.
Okay, next is going to be Craig Webster.
Okay. Mr. Webster, you've been charged with 1 count of battery. Bond is going to be set at $5,000 for that. There's also going to be a stay away provision on the bond to stay away from a Danielle Webster, and I set the same bond amount for her. And this provision can be changed if whatever led to the two of you before me today was just an incident that will be worked out or can be worked out. Do you understand the stay away provision, sir?
Yes, sir.
Do you believe you can be on?
Yes, sir.
Would you like for me to see if you qualify for the appointment of a lawyer?
No, sir.
You're going to hire your own lawyer?
Yes, sir.
Okay. Do you have any questions of me, Mr. Webster?
No, sir.
Okay, you're free to go back.
Last one is going to be Mr. Woods. Tobias.
Mr. Woods.
Yes, sir.
You've been charged with stolen property, violation of Georgia Controlled Substance Act as it relates to possession of cocaine, and possession of drug-related objects.
Yes, sir.
The bond is going to be set, total bond, at $11,500. Do you believe you can post that bond, sir?
Yes, sir.
You're going to have a preliminary hearing date that's going to be set for April 7th. So that date is going to get waived upon your bonding out.
Yes, sir.
Would you like for me to see if you qualify for the appointment of a lawyer?
I'm hiring my own lawyer.
Okay. If you don't have any questions of me, Mr. Woods, you're free to go back.
Thank you, sir.
Okay.
Okay, Your Honor, the last one is going to be Lee.
Let me ask you a question. Is Mr. Suma, Soumah, is he OTB?
Yes, sir.
Okay. All right, Mr. Lee, I'm ready for Mr. Lee.
Ready?
Mr. Lee, you are in a special sort of position. The term is fugitive from justice, but basically what that means is that there's another state that has a warrant for your arrest, and they said that they want to bring you back to that jurisdiction. You're not charged with violation of any criminal offenses here in Clayton County. You are, looks like it says you have a warrant for your arrest out of the state of Indiana.
Yes, sir.
And this says you're charged with possession of a controlled substance. So the way that the extradition process works is that if you believe that you're not the person named in the warrant, or that the charge in the warrant is improper, you can fight that here. And the only thing a judge will have to determine is whether you are the person named and whether the charge really exists.
What's the charge again?
It says that you're charged with possession of a controlled substance out of Indiana.
If the charge is wrong and I fight it, I can be released from here because that's not the charge. The charge is supposed to be something completely different.
So what will happen here is that the first thing the judge will determine is whether you are the person named in the warrant, like whether you're the appropriate person, and then whether this is a charge that is a criminal charge. The judge will not determine sort of the underlying facts.
Right, gotcha. But like, what I was asking, like the charge we're saying is possession, but the charge is something totally, completely different. It's not even drug related. I don't know where the possession charge came from. My warrant is not nothing to do with any kind of drugs.
There is, so I've been a criminal defense lawyer for like 20 plus years. And I've dealt with these charges, these sort of issues before. And generally, the way that we would deal with it is we would deal with it in, like it says, Indiana. So we would go to Indiana.
My charge is forgery, not possession.
Okay. Well, I'll finish with my thought, but then I'll go back to what you just said. I've had clients who we've been able to successfully fight the extradition. And basically, they don't want to spend the money to come get the person from wherever they are. And they're more than willing, once they know the person has a lawyer, to call the receiving jurisdiction, which will be Clayton County, and say, "Hey, we're lifting our decision to extradite that person, and you can release that person," and that person gets released from jail. But it's been stuff that has been worked out on the back end to say, "Hey, we're going to come back and we're going to fight this and we're going to deal with this." And so in your situation, it would be Indiana. So if I was your lawyer, I would deal with Indiana and get them to lift the decision to extradite. It benefits them because they don't have to pay a cop or an officer, detective, whomever to fly to Atlanta and pick you up and then fly back. So they don't have to deal with that. In circumstances where it was like charges were like bogus, we fight the charges and just deal with that. But for you, and what you need to understand so that you can make the decision that you need to make is that the total time can be up to 90 days of your sitting here in Clayton County and trying to figure this out. If you believe, as you said to me, that you're charged with something totally different or whatever, and you think that you can beat that, then you may want to fight the extradition hearing. And you'll have a hearing sometime within the next 30 days here in Clayton County as it relates to the warrant that you're being held on. And if you're successful, then you're going to walk out the door of the sheriff's department. If you're unsuccessful, then there's going to be a period of time where Indiana has to come and get you. And that clock will begin to run the day of the hearing. So if there's a hearing and you're unsuccessful, the clock begins to run that day. If you believe that you can win this, it's something that you may want to consider waiving the right to that hearing, but also fighting it on the back end in Indiana if you have a lawyer that's there
So if I sign the waiver, how long do they have to come get me?
I'm sorry.
If I just sign the waiver, they can just come get me and get over with, right? Just go get it done.
Yes. Is that what you want to do?
How long do they have on the waiver if I sign the waiver?
I'm sorry.
If I sign the waiver, how long do they have to come get me?
Basically up to 60 days.
But if I don't sign the waiver, I can fight the charge, correct? Because the warrant's not right. Can they reissue the correct warrant after this?
Yes, they can.
So they can fix it and then reissue it. I'm still sitting here anyway, right? So I'm just gonna sign the waiver. I'm just gonna sign it. I'll sign the waiver.
Okay. So the deputies will give you the paperwork, and you'll sign it, and then they'll send it to me, and I'll sign it, and then the clock begins to run today. But I would encourage you that if you believe that this is something that is wrong, it's in your best interest to have somebody to fight this in Indiana.
And I definitely have a warrant in Indiana. It's just not that warrant. I don't know where that came from. That's my brother. We got co-defendants. He got the drug charge. I got the forgery charge.
Okay.
I definitely have a warrant there for sure. I'm not denying that fact at all. So I mean, either way I go, even if I beat this warrant, I have that warrant. So I mean, it's one warrant. So I know I got a warrant, period.
And and I'll say this to you, Mr. Lee. I mean, during this whole COVID stuff and everything that's going on, jurisdictions they're kind of stretching stuff that they would normally not do. They're doing. So you may be able to work this thing out where you don't have to go back. So, if you got somebody that can advocate on your behalf, I would suggest that you do that.
I got people on it right now already.
Okay. Anything else, Mr. Lee?
That's it, sir.
Okay, you're free to go back.
Yes, sir. Good one.
All right, y'all, that's it.
Okay, I do apologize. Today has been a bad day. So you have a good evening. Hope you have a good weekend. And I'll be back on Monday.
Yes, sir. You have a good weekend as well.
Okay.